An Indiana woman is accused of allegedly beating and stabbing a man as he was trying to get into the shower. Even though the victim was allegedly able to point the finger at her, he has now died, and she is facing upgraded murder charges. An Indiana criminal defense attorney is here to talk about just how much trouble she could be in. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, let's talk about Briley Turner. So the 25-year-old was arrested back on August 18th for aggravated battery. This is a level 3 felony in Indiana, as well as attempted murder. Now, this is according to officers with the Bloomington Police Department, but they say Turner had attacked a 36-year-old man named Michael Hodge inside of her apartment, causing severe injuries. Also, we put Briley Turner's name into the search box on TruthFinder, and we were able to see a criminal history that dates back several years. Most of the charges involve drugs, including possession of cocaine and marijuana, as well as driving while intoxicated. And I'll tell you what, we actually use TruthFinder a lot. We use it to research our stories. Sometimes what you find on there is pretty shocking. Even typing in your own name, you might be surprised at what comes up. So TruthFinder is one of the largest public record search services in the United States, and you can also use it to pull up registered sex offenders in your area, which is super helpful for peace of mind. And with a paid subscription service, you can get access to unlimited reports about almost anyone. So if you're interested right now, you can get 50% off of your first month of confidential background reports. Just go to truthfinder.com/LC-sidebar. Okay, back to the case. Neighbors called 911 reportedly at around 7 p.m. that Sunday, August 18th, to report that they could hear a man and a woman both yelling. And it sounded like at least one of them was shouting, "Help." Now, officers at first could only really hear loud music coming from the apartment. Then they were able to hear the screaming. So they break down the door. They find Turner lying on the couch covered in blood, but it turns out that blood wasn't hers. No, Michael was on the bathroom floor with multiple stab wounds. That's the report. According to a criminal complaint, quote, during officers' initial observations of the bathroom, it was determined that there was a bloody plastic handle to a kitchen knife with the metal knife portion missing near the bathtub. Additionally, there was a bloody black-handled tire plug tool with a metal spike on it located on the floor nearest to the sink. Lastly, in the main living room of the apartment, to the right of the main door, was a bloody baseball bat leaning against the wall. So you have 3 deadly weapons, a victim who's gravely injured, and a suspect covered in blood. Just imagine what an awful scene that was. So when the detective gets to the emergency room, doctors told him about Michael's very serious wounds. He had stab wounds to his chest, rib cage, neck, quad, upper right buttock. Part of the knife, which they found broken in the bathroom, was still inside Michael's body. He also had a broken arm with part of the bone sticking out. So this is a really, really horrific attack. Gruesome stuff. Now, police, and this is important, they were able to speak with Michael, and he told them that he had been getting into the shower and thought that Turner was going to join him when she suddenly attacked him out of nowhere. He alleges that she started with the baseball bat, then switched to the knife. He said he tried to grab the knife away from her, but he only ended up with cuts on his hand. And Michael said that there hadn't been any sort of argument or altercation before she hit him. So Turner, going back to her, she was also taken to the hospital. She had blood all over her hands and arms, but again, none of it was her own. According to the criminal complaint, quote, as medical staff attempted to evaluate Briley, she would not talk to them and also refused to speak with officers. During this time, she repeatedly made jerking motions with her extremities and loud moaning and whimpering noises, but would not communicate directly. The detective also noted that Turner had yellow and purple bruises on her legs and sides that appeared to be older. So now that's important because if we're talking about new injuries, it doesn't appear from this at least that there were new injuries. And why is that important? Because an officer who was with Turner at the scene documented that, quote, Briley made statements to him on scene stating, he tried to get me. He effing tried. He effing held me down, and he tried to put that stuff down my throat. I don't know what he put in my throat, and I had to defend myself. Dude, I tried to defend myself. After making these statements, she began hyperventilating and would not communicate with officers. The statement goes on to say, quote, While being placed under arrest, Briley complied with all orders. She was able to stand on her own, listen to commands from Officer Wells, and got into and out of a wheelchair on her own. While in the back of Officer Wells' squad car, I again asked Briley if she would talk to me, to which she shook her head no. The detective ended the criminal complaint by stating, quote, based upon the facts and circumstances of this investigation, it is my belief that Briley Turner knowingly and intentionally inflicted injury on Michael Hodge that created a substantial risk of death, committed aggravated battery. And then things took a turn. Things took a very bad turn because Michael died on September 11th at the hospital. The Marion County Coroner's Office ruled his death a homicide. Now, I should tell you, at the time of this recording, it is being reported that the charges have been upgraded, that she has now been hit with the most serious charge, murder, attempted murder, aggravated battery in connection with what happened. But some people online have actually compared this case in a way to the Jodi Arias case. Remember her? She was the woman convicted of first-degree murder for the brutal stabbing death of her boyfriend, Travis Alexander, in Arizona back in 2008. He was found in a shower with 27 stab wounds, a slit throat, a gunshot to the head. Now, Arias had said that it was self-defense. The jury didn't buy it. During the penalty phase, they deadlocked on the death penalty, so she was sentenced to life in prison without the possibility of parole. And of course, Travis Alexander, he couldn't tell investigators what happened to him, but Michael was able to communicate and say what happened to him, pointing the finger right at Turner. So now let's talk about this. I'm joined right now by Mark Worthley, an Indiana criminal defense attorney. Thank you so much for coming on, Mark. Appreciate it. As a defense attorney, what's the best defense here? Is there one?
Well, obviously her statements when she was confronted by the police initially would lead you to think that she wants to make a self-defense claim, but probably it's more likely going to be an insanity type defense. Because there's no injuries on her, I think it would be really difficult to make a comparison between the number of stab wounds that the victim had to essentially no visible injuries and say that she was defending herself. So I think self-defense is probably going to be a stretch for her. And then when you compare that to the statements she was making to the police, the language she was using, and the movements that they're describing, that would probably lead a defense attorney to want to make a claim of insanity.
But that would be tough to prove, right? That's tough to prove in any case. But I feel, well, I mean, some of the things that she was saying was pretty out there. But what would an insanity defense have to look like here? What facts would you need more of to actually mount that in Indiana?
They would need to get an expert involved, somebody who would be able to say that her mental capacity at the time of the offense was degraded to the point that she wasn't able to appreciate the wrongfulness of what she was doing.
I guess the question is, going back to your defense, putting insanity for the side, if you go back to the idea of self-defense, right? Do you need to have injuries on your body? Have you seen cases where somebody, they're in a position where they think they're about to be attacked, but maybe they don't have to wait to be attacked, and they ultimately can mount self-defense? Here, the argument's strange because it sounds like there was some sort of physical confrontation. And I think what's really difficult for her is multiple weapons that were allegedly used.
Right. There would not need to be an injury. But in this case, there's only two witnesses. And the fact that there's not somebody there to corroborate that he was attacking her. So her statements would be viewed as self-serving by a jury, and there wouldn't be any corroboration to her to say that the self-defense claim was anything more than just a get out of jail free card for her in that instance. But yeah, in a lot of instances, especially if you were dealing with two guns, the victim and the perpetrator both had guns, then it would be a little bit easier to say, well, I shot first because I wasn't going to wait till he shot me. And then there wouldn't be any injuries. But yes, self-defense in this case, I think, is going to be torpedoed because she doesn't have any injuries.
And to have the victim speak, because how many times in trials do we hear we're representing the victim's voice. This is them crying out from the grave. This is the grave. This is them saying what happened. It's not true that they're trying to say there were other ways that a victim would say, this is the person who killed me. Here you actually have a victim explaining what happened to them before they ultimately die. And I'm curious about the impact that that statement would have, both in terms of mounting a self-defense argument or prosecuting the case, but B, the very act of a jury hearing the last words, the dying words almost in a way, of a victim. That's I feel very tough for a defense attorney to find a fair and impartial jury that's not going to be swayed by that.
This will be a really big issue for them at trial because that statement is hearsay for certain. And then the question will be is whether or not a judge would let the statement come in, even though it's hearsay. So there would be two different ways that they could evaluate it. One is whether or not the statement was made and the person making the statement believed that he was imminently about to die.
Right.
That would be extremely fact sensitive. Was it at the hospital? Were they telling him that he was potentially going to die? Or had he recovered? Was he conscious and stable? In which case, then now the evaluation has changed because he has died and he's unavailable to testify. So there are a few more options that the court could let that statement in, but the defense is going to push really hard to keep that out. I don't know how that's going to play out, but once the statement comes in, then the reason why it's hearsay and the reason why this will be a big issue for the defense is because it will be such a damning statement and there won't be any cross-examination available to say, easy for you to say this happened when you're at the hospital talking to the police and maybe who knows what cross-examination questions they would have wanted to ask, but it's not available to them.
And to be clear, the way that you would get this evidence in is the people that he allegedly made these statements to, right? Like the first responders or law enforcement, they would testify about what he told them, and you could cross-examine them about what they heard, right?
Yeah, you can't really cross-examine a police officer on what he heard. I mean, the only cross-examination question would be are you sure you heard it right? It wouldn't be like, well, when you want to talk to the victim about saying that she went crazy, she lost her mind, she stabbed me, you couldn't ask her any questions like, what preceded that? What did you do to her? What did you try to put down her throat? Obviously, that's what she said, but.
Right. Let me ask you this. If this goes to trial and she mounts a self-defense argument, she has to take the stand. I mean, what I mean by that is she doesn't have to take the stand. It's her choice. But in a self-defense case, it's when we see, I think it's one of those rare times in the law we actually think it's a benefit for a defendant to take the stand, explain their side of the story, explain the danger they were in. She would have to do that, right, in this kind of case, to explain the danger that she felt?
Yes. So self-defense is flipping the burden onto the defendant. So you may have heard numerous times that the burden is on the prosecutor to prove the guilt. So the defendant doesn't have to take the stand, doesn't have to do anything, and the jury can still be compelled to find the defendant not guilty, even if the defendant presents no evidence, because it's the state's burden. The state has to do things to convince you that the defendant is guilty. But if you allege self-defense, you plead that, and then you seek to prove it, you have to present evidence. Otherwise, the self-defense claim fails. So she would need to take the stand, testify about what happened before the attack or during the attack, and prove to the jury that she was defending herself. And she also has to essentially admit that the attack happened. If she pleads self-defense or if she makes that argument, she's essentially admitting that she attacked him and killed him, but she was justified in doing so.
And by the way, if she were to take the stand, the other past criminal history that she may have, she could be questioned about that, right? That could hurt her in the end.
Anything that she has that would relate to her ability to tell the truth, or for a jury to infer that she was telling the truth, would come in, and possibly some of her other convictions as well.
All right, so it's an interesting case, sad case to say the least. An interesting one from a legal perspective, though. We'll continue to follow it. Mark Worthley, Indiana criminal defense attorney, thank you so much for coming on. Appreciate it.
You're welcome.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.